Okay, Mr. Clerk, you want to ring the bell? The clerk will read the caption to a group of privileged resolutions. The clerk will read.
Honoring the life and memory of Kenneth Saunders III. Recognizing and commending Dr. Joseph C. Barrow, Jr. Commending Taiwan ROC for its efforts in aiding Georgia in the fight against COVID-19. Commending Cindy Purdue Moore for her leadership and committed service to the University of North Georgia, the larger surrounding communities, and the entire state of Georgia. Recognizing August 2020 as National Minority Donor Awareness Month. And for other purposes, that completes the reading of the privilege resolutions.
Is there any objection to adopting the privilege resolutions? The chair hears none, and the resolutions are adopted. We are about to go on to the rules calendar. We're about to go back to the rules calendar. Mr. Clerk, you want to ring the bell one more time? Clerk will read the caption to Senate Bill 315.
Senate Bill 315 by Senator Tippett of the 37th, Dugan of the 30th, Cowsert of the 46th, Stone of the 23rd, Ligon of the 3rd, and others, being entitled Act to amend Part 3 of Article 8 of Chapter 14 and Title 44 of the Official Code of Georgia annotated relating to mechanics and materialmen, so as to provide that a waiver and release of lien and bond rights shall only be applicable to the issues of the waiver and release. This bill having referred to the Committee on Regulated Industries. That committee recommends that this bill do pass.
Chair recognizes Representative Washburn to present the bill.
Thank you, Mr. Speaker. Ladies and gentlemen in the House, I come to the well today to present Senate Bill 315, which was authored by Senator Tippins of the 37th Senate District. This bill has to do with revisions to the Georgia lien law. The Georgia lien law is very complex, and so in order to explain this bill, I want to just tell you a little story. Lien law, a lien is evidence of money owed against a piece of real estate. And this revision deals in particular with materialmen's liens, which is what a contractor has the right to do to file a lien against a piece of real estate if he doesn't get paid. I want to tell you a story about an electrical subcontractor who's doing work here in Georgia on a large housing project. As an inducement for him to receive payments in increments as he went along with the work, he signed what is known as a lien waiver, and he began to be paid. The problem is, when he got to the end of the road for the last payment, he did not get paid. And when he tried to file suit against the contractor in order to force him to pay him, he learned that because he had signed a lien waiver, he had also waived his right to file a suit for breach of contract on payment. So the spirit of this bill is to clean that up so that that would not happen. This bill was passed unanimously in the Senate, I believe, and it also has 20 groups in Georgia who are in support of it, and that is folks such as the Georgia Chamber of Commerce, Associated General Contractors, Independent Electrical Contractors, Atlanta Electrical Contractors. A long list are in support of it. It was passed out of our Regulated Industries Committee by Representative Billy Mitchell, a member of our minority. It has broad support. It is a good bill. It's a fair bill, and it's a bill that ought to pass. And so I urge your favorable consideration of it, and I will yield for any questions, Mr. Speaker.
Let's see, I think you had some questions.
I will yield.
Well, Chairman Powell, do you have a question or not? Okay. You do not appear to have any questions.
Thank you, Mr. Speaker. I yield the well.
Chair recognizes the minority leader to speak to the bill.
Thank you, Mr. Speaker, and I'll be very brief. This is a good bill. Occasionally in my small town country law practice, I get a call from someone who's done some work, a contractor or in construction, and they run into this issue. And the bill provides some necessary clarification in the mechanics and materialman's lien law. There's a 90-day period for you to file a lien against a property. And with a non-payment on the lien waiver, under present law, it's 60 days. And this bill changes it from 60 to 90. And the importance of that is that when people are working, they're thinking about the 90 days. And when they're signing this lien waiver, they're thinking they have 90 days and the law says 60, and there's some people out there who unscrupulously use the current law as a loophole not to pay folks for work that's been performed. And this bill seeks to close that loophole, fix the law. So I'd urge your favorable consideration and passage of this bill, and thank the gentleman for bringing it and doing the excellent job explaining it. Thank you, Mr. Speaker. I yield the well.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote aye. Those opposed will vote no. And the clerk will unlock the machines.
Alexander, Manolowitz, Barr, Barton, Belton, Bentley, Benton, Beverly, Blackman, Bodie, Bruce, Burns, Carpenter, Carson, Chokas, Clark H., Collins, Cooper, Corbett, Dempsey, Dickey, Dollar, Drenner, Dubnik, Efstration, England, Irwin, Fleming, Fry, Gaines, Gardner, Glanton, Gravely, Harrell, Hatchett, Hawkins, Hitchens, Holcomb, Holmes, Houston, Hughley, Jackson M., Jaspers, Jones J., Kelly, Kendrick, Knight, LaHood, Laricchia, Lumsden, Martin, Mathiak, McCall, Morris G., Newton, Nix, Oliver, Parrish, Parsons, Petrie, Perkel, Powell, Reeves, Rhodes, Rich, Ridley, Rutledge, Scoggins, Setzler, Silcox, Smith L., Smith R., Smith V., Smyrie, Stevens R., Tankersley, Tanner, Tarvin, Taylor, Thomas E., Trammell, Washburn, Watson, Welch, Werkheiser, Wiedauer, Williams A., Williamson, Yurda, Allen, Bazemore, Bernau, Cannon, Carter, Clark D., Clark J., Cook, Davis, Douglas, Dreyer, Donahue, Earhart, Evans, Frazier, Gilligan, Gertler, Henson, Hill, Hogan, Holland, Holly, Hobson, Howard, Hutchinson, Jackson D., Jones S., Jones T., Jones V., Couch, Kennard, Lopez Romero, Marin, McLean, McLaurin, McLeod, Meeks, Mitchell, Moore B., Moore C., Morris M., Nelson, Wen, Paris, Prince, Pullen, Robichaux, Saints, Schofield, Scott, Shannon, Sharper, Smith M., Stevens M., Stevenson, Thomas A.M., Turner, Walensky, Wilkerson, Williams M.F., Williams N., Wilson, Beasley Teague, Bonner, Buckner, Beasley Teague, Bonner, Buckner, Mike isn't working at 341.
Can DJ go over there? We only have one microphone. Do not have extra batteries over there. I can put it on speakerphone.
Buckner.
Is it working in y'all's room? Is it working in 341? They can hear the mic in 341. We just can't hear it in here. Okay, DJ's coming over there. Do you want me to put her on
Yeah,
speaker?
but I don't even know that they can hear me. Because
They can, they
I'm not
can
getting
hear
the
you.
feedback that I've been
They
getting.
can hear you. Okay, Isabella, I have you on speakerphone, okay?
All right, Buckner. Burchett. Caldwell. Campbell. Cantrell. Dickerson. Dukes. Gamble. Gilliard. Gordon. Green. Gullett. Jones, J.B. Kirby. Lott. Mathis. Metz. Momtahan. Park. Pruitt. Rogers. Singleton. Stovall. Williams, R. Alexander. Allen. Beasley Teague. Bennett. Bentley. Benton. Beverly. Bodie. Bruce. Dempsey. Drenner. Dreyer. Gilliard. Hughley. Jackson D. Jaspers. Jones V. Knight. Laricchia. Morris M. Rhodes. Smith L. Smith R. Smyrie. Stevens R. Williams R.
Okay, members will look at the board and make sure that it is accurate. Make sure that it's accurate. Mr. Clerk, you may lock the machine. On the passage of Senate Bill 315, the ayes are 147, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. If you have request, I understand that Chairman Smith may have a Rules Committee meeting here shortly. You might want to get those to him. Clerk will read the caption to Senate Bill 391.
Senate Bill 391 by Senator Kirkpatrick of the 32nd, Watson the 1st, Albers the 56th, Burke of the 11th, and others, to be entitled an act to amend Article 1 of Chapter 24 of Title 33 of the Official Code of Georgia annotated relating to general provisions regarding insurance so as to require health insurers to provide coverage for early refills of a 30-day supply of certain prescription medications. This bill having referred to the committee on Special Committee on Access to Quality Health Care, that committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Cooper to present the bill.
Thank you, Madam Speaker. I bring for you today Senate Bill 391. This is about prescriptions refills in times of an emergency situation like we have now, or if we have a hurricane. People who are leaving the area of a hurricane often early have been having trouble getting a 30-day supply of their medicines ahead of time as they leave, and this would override that. If the governor had declared an emergency or there was a hurricane warning by the National Weather Service and had been put in effect, you would only be able to give the refills for 30 days. If they were refillable, no Schedule IIs, and the prescriber would have to be notified in 48 hours. I ask for your favorable consideration on Senate Bill 391. This is to help people in emergency situations, and we have had problems with people unable to get their medications in the past, especially during hurricanes. Thank you very much. I'll be available for questions if we have any, Madam Chair.
There appears to be no questions.
Thank you, Madam Speaker.
The lady has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. And the clerk will unlock the machine and call the roll.
Alexander, Hanulowitz, Barr, Barton, Belton, Bennett, Bentley, Benton, Beverly, Blackman, Bodie, Bruce, Burns, Carpenter, Carson, Chokus, Clark H., Collins, Cooper, Corbett, Dempsey, Dickey, Dollar, Drenner, Dubnik, Abstration, England, Irwin, Fleming, Fry, Gaines, Gardner, Glanton, Gravely, Harrell, Hatchett, Hawkins, Hitchens, Holcomb, Holmes, Houston, Hughley, Jackson M., Jaspers, Jones J., Kelly, Kendrick, Knight, LaHood, LaRicchia, Lumsden, Martin, Mathiak, McCall, Morris G., Newton, Nix, Oliver, Parrish, Parsons, Petrie, Perkel, Powell, Reeves, Rhodes, Rich, Ridley, Rutledge, Scoggins, Setzler, Silcox, Smith L., Smith R., Smith V., Smyrie, Stevens R., Tankersley, Tanner, Tarvin, Taylor, Thomas E., Trammell, Washburn, Watson, Welch, Werkheiser, Wiedauer, Williams A., Williamson, Yerda, Allen, Bazemore, Bernal, Cannon, Carter, Clark D., Clark J., Cook, Davis, Douglas, Dreyer, Donahue, Earhart, Evans, Frazier, Gilligan, Gertler, Henson, Hill, Hogan, Holland, Holly, Hobson, Howard, Hutchinson, Jackson D, Jones S, Jones T, Jones V, Couch, Kennard, Lopez Romero, Marin, McLean, McLaurin, McLeod, Meeks, Mitchell, Moore B, Moore C, Morris M, Nelson, Wen, Paris, Prince, Pullen, Robichaud, Saints, Schofield, Scott, Shannon, Sharper, Smith M, Stevens M, Stevenson, Thomas A.M., Turner, Walensky, Wilkerson, Williams M.F., Williams N., Wilson, Beasley Teague, Bonner, Buckner, Burchett, Caldwell,
Hang on just a second. I think there was a delay and I got behind. Caldwell is next.
Caldwell, Campbell, Cantrell, Dickerson, Dukes, Gamble, Gilliard, Gordon, Green, Gullett, Jones, J.B., Kirby, Lott, Mathis, Metz, Momtahan, Park, Pruitt, Rogers, Singleton, Stovall, Williams R, Bennett, Bruce, Clark J, Dreyer, England, Fry, Gilliard, Holcomb, Hughley, Jackson D, Jaspers, Jones J, McLeod, Netz, Morris M, Smith M.
Have all members voted and checked the accuracy of the board? If so, the clerk will lock the machine. On the passage of the bill, the yeas were 148, the nays were 0. The bill, having received the requisite constitutional majority, is therefore passed. Clerk will read the caption to Senate Bill 405. Senate Bill 405.
Senate Bill 405 by Senator Tippins, the 37th, read of the 33rd, Kirkpatrick, the 32nd, Jordan, the 6th, Thompson of the 14th, and others. Be titled an act to amend Code Section 15.6.2 of the Official Code of Georgia Annotated relating the number of Superior Court judges for each judicial circuit so as to provide for an 11th judge of the Superior Courts of the Cobb Judicial Circuit. This bill having referred to the Committee on Judiciary. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Welch to present the bill.
Thank you, Madam Chair. Members of the House, I have before you Senate Bill 405. Let me begin by saying that what we've done in judiciary is we took the Cobb County judgeship that was previous in 405, we have moved into and put all the judgeships into one bill. That bill is House Bill 786, which is in the Senate. So the Cobb judgeship, the Ogeechee judgeship, and the Flint judgeship are all in one bill, and that was done by the Senate Committee on Judiciary, with the idea that we try to get through one bill rather than trying to chase three around this chamber during this COVID crisis. With that, that opened up this particular legislation, and as you know, being the chairman of Appropriations on Public Safety, I interact with a lot of the judges throughout the state, and in working through the budget and trying to understand some of the issues that we were seeing in courthouses, it became apparent that the ability for the administration of justice and to have a jury trial was going to be very difficult under these circumstances. You know that the Chief Justice of the Supreme Court has issued 3 judicial orders, postponing deadlines and limiting the effect of having jury trials. This measure that you have before you is a simple measure. What it does is it codifies and allows for us to go to 6-person jury trials in the Superior Court with the consent of the parties. So both parties have to consent. If it's a civil case and if it's a criminal case, both parties have to consent, which currently that's the way it operates under case law. It's not in our statutes, but this helps the judges understand that they can do that if both parties consent. That means the defendant has to consent and the prosecution has to consent to moving to a smaller jury. What does that mean? That means that a smaller jury pool is brought into the courthouse, which means you can separate people apart, maintain good social distancing, not any different than what we're doing in this room now. Imagine that in some of our courthouses across this state where space is limited. And if you can separate out, we can get a pool of jurors of 12 or 24 as opposed to 40-something in a room. They can be selected through the process and then sit as an impaneled jury for a trial with 6 members spaced out in the jury pool. In that sense, we can actually move these cases along, and that's what this bill is at its heart all about. We are affording the judges clear direction in our statutes and code to go to 6-person juries in state court, which they can do now anyway, but this would allow for them to do that, the judges to use their discretion in determining when that should be appropriate for civil cases, not criminal cases, civil cases in state court, and only consent of the parties in Superior Court for civil and criminal. And this way, we're hoping to move this along. Now, there's a critical part of this bill, and that is that it has built-in sunsets. It only begins July 1st of this year and runs until June 30th of next year. And that is because we traditionally go for 12-person juries. That's traditionally the way we do things. But in this crisis period, and in order to allow people that have a case where they think a jury needs to hear it, they can go for a 6-person jury and they can get ahead of the line. Think about those defendants who believe that they've been wrongly accused, or that they will convince a jury that their case should be dismissed, they should be acquitted. Those individuals are going to be waiting in jail or on bond for a long period of time trying to get through their case for a hearing. And this would allow them an expedited way to get that case heard, decided, and out of the way. If you're a civil case and you are in a posture where your case has been sitting for a long time, in a way that person, the plaintiff, is a person who's been harmed in some way, monetarily. And right now, that case could be held up as we try to go through jury trial after jury trial after jury trial, trying to get those organized and heard, and that could drag out for much longer. And this would help us to move through the process where those parties consent to doing it, or where a judge thinks, in state court only, where a judge thinks that it's appropriate that it move on to a 6-person jury. Now, it can be a 9-person jury the way this code section's written, and there may be some negotiation between plaintiff's counsel and defense counsel over that. But that gives even more flexibility to the law than we currently have. So with that, I would ask for your favorable consideration. I do want to take questions because this is a very important issue, and I've spent a lot of time trying to talk to individual members in this chamber, and I do want to make sure that I address your questions and concerns. I think this is a good bipartisan measure to help our courts and help our judges and help those that are sitting there waiting for a fair trial in our court system.
There are a couple questions. The chair recognizes Chairman Setzler for a question.
Does the gentleman yield?
Yes, I do.
Appreciate you bringing this. I did have some grave concerns about this, and I think you've called some of those, but I do have a question or two,
Yes,
specifically about the felony proceedings.
correct.
I was concerned that, when you go from a 12-person jury down to a 6-person jury, it's got to be unanimous. Getting unanimity for conviction with 6 people is a very different proposition than getting unanimity from 12 people for conviction, so you can understand that balance.
Absolutely.
My concern is this becomes precedent setting. I think I really have concerns with this. I think the thing that it's only with, I want to confirm, it's only with a consensus of both parties. Both parties can, if either party were to object and would insist upon 12, they could still by right have a 12-person jury in a felony.
You are correct.
Okay. With respect to, does the gentleman further yield?
I do.
With respect to the jury strikes, I know it enumerates in subsection A the people that are initially called from which the strikes happened. 30 persons in a traditional case. Do you still start with the same 30 and strike down to 6? Or is that number of people that are called reduced as well? And in either case, do you have the same number of strikes in paneling that final jury?
We have not altered the number of strikes that are traditionally afforded to the parties, which I think is 3 on each part. Criminal law is not my area of practice, but I'm sure a member will correct me if I'm wrong. And no, we have not altered any of the altered that impaneling of the 30 jurors. If the parties do consent, both the defendant and the prosecuting the state consent to that, then I'm going to assume that the judge and those parties will decide how big of a panel that they may need to move forward with the case. But as this is written, it doesn't alter current law as to the empanelment of those jurors.
Okay, because again, just to the gentleman, I would say, I can't speak for this body, I can only speak for myself, but with respect to legislative intent, I would have grave concerns if this becomes a pattern for us to be contemplating 6-person juries for felony cases. And I think the intent that I would certainly expect coming out of this is there's no less strikes and that we get back to 12 as soon as we possibly can for felony juries.
And that's, and I'll direct the attention to the members that if you haven't looked at it, line 69 and 70, the last underlying portions of the bill, this subsection shall stand repealed by operation of law on July 1st, 2021. So it is truly for 1 year. And again, I'll also point to you that line 66, it does say after the introductory clause, with consent of the parties, with the consent of the parties, requiring that there be consent of both parties in order for it to move forward as a 6-person jury. And there may be, in most instances, I think we'll see people go to a traditional 12, but there may be instances where an individual believes that a fair trial will be given to him or her as a 6-person panel and would like to have that trial, be acquitted, and the bonds removed or lifted on that person, or them be able to exit whatever confinement they're in. So this is a measure that I think I deeply appreciate the chairman's points, and that is why I specifically we have this thing set for specific repeal this time next year.
Chair recognizes Representative Vance Smith for a question.
Gentleman, you.
I do.
So help me understand, we're allowing the two-party consent in Superior Court, but in state court we don't allow that. What would be the reason? Why wouldn't it be the same in both?
It is the same in both in this bill. The one difference, and I'll point it out to everyone in the body, is at line 20. You'll read it obviously line 26, but as you read through line 26, where it comes in at line 28, you'll see that it says a jury of fewer than 12 persons, but no fewer than 6, which gives you the range. at the discretion of the trial judge or by consent of the parties. So, Representative Smith, I think your point is about the discretion of the trial judge. So in there may be situations in which the trial judge has seen this case, reviewed, knows what how the parties are acting in the case has languished for long periods of time. It may be such that if the judge believes that this case should be tried and it needs to be tried in a timely fashion, then that would give the judge the ability to go in and call for that jury trial of 6. What does this really do? 2 things. Number one is that it will force people to settle cases if they're being obstreperous, they're being stubborn, engaging in stubborn litigiousness, they're dragging out cases. It will allow judges to force the hands on those civil cases, civil, not criminal, civil only, in state court. Number 2, those people that really want the 12-person are probably going to go into the judge's chambers at a call. What judges do, they call people in, they ask for, it's called a calendar call. What's going to happen is a lot of folks will say, I'll take my 6-person jury, judge, we'll go forward with a 6-person jury. Other groups will say, I want the 12-person jury, and that's going to essentially bifurcate the set of cases that are out there and move those persons that are 6-person juries are going to go first and get through first before you get to 12-person. So that way we're creating some efficiencies, but I'm leaving it at the discretion of the trial judge because I feel like that they know their courthouses best, they know their systems best, and they know what occupancies they can handle.
One more question.
Yes, sir.
So that trial judge, are we talking about a trial judge in Superior and state court?
No, just state court. Just state court. That section there, Representative Smith, section 15-12-121 only deals in state court, and the section below that in B, the A deals in state court, B deals in Superior Court. You'll see Superior Court at line 35.
Chair recognizes Representative Wilson in the gallery for a question.
Does the gentleman yield?
I do.
Mr. Chairman, isn't it true that this bill, as drafted, has the support of the Judiciary Committee, members of both parties, and the Georgia Association of Criminal Defense Attorneys, Southern Center for Human Rights, the Prosecuting Attorneys Council, Georgia Trial Lawyers Association, and the Criminal Defense Bar?
I believe that on the first 3, I believe that I have written and I've emailed to every member of this House a copy of the memorandums issued by the Georgia Association of Criminal Defense Lawyers, signed by their executive director, and the Southern Center of Human Rights, signed by their executive director, in support of this measure, as well as a letter sent by Prosecuting Attorneys Council in support of this measure. As for the other 2 groups, I cannot speak to their support. I understand that they are neutral on the bill. I have received information from members today for the first time that this bill has been vetted on Tuesday, heard on Tuesday. We spent a long time, as Representative Wilson knows, on this particular measure. I've just now received text from members, but from no organization outside of these chambers that has indicated any opposition to this. Some members have told me that there are 2 organizations that are opposing this, groups representing doctors for fear of large settlements in state court. And what I say to you and what I would say to them is this: if you're afraid of a jury in this state awarding a victim of negligence, then maybe you should settle your case.
Would the gentleman yield for one more question?
Yes.
Mr. Chairman, isn't it true that this bill is a delicate balance of ensuring Georgians' constitutional right to a jury trial, but also understanding the unique nature of the pandemic that we're in and allowing them to be able to efficiently move their case through the system given the constraints that we're under?
It does. It allows those people who are perfectly comfortable with the 6-person jury deciding their case to get those cases heard. Let's get those out of the way. Let's move them forward. Let them get priority in the list. Move those cases forward. This bill would make it very clear from a public perspective, from a public statement in this body, and hopefully the Senate as well, that this is law, this is permissible, this is a procedure you can use to expedite your cases and get a resolution. And to the gentleman's point, if I may, I want you to, everyone in this room know that I reached out to both the Insurance Defense Bar as well as the Georgia Trial Lawyers organizations and informed them of this bill last week, sending out copies, discussing this measure with them, taking in and soliciting their comments. And that's why I think they've taken a neutral position on it, because we've done the advance work to try to inform them of where I was headed with this measure. I've done what I can do to reach out to organizations, but we are the deliberative body. I don't make decisions based upon what a special interest group tells me they want done. We make decisions based upon deliberation, discernment, and wisdom, and a motivation for the administration of justice. And I believe that this bill accomplishes this particular, all of those goals for the limited time that we hopefully are engaged in the COVID pandemic across the state.
Thank you very much for bringing this important bill.
Thank you, sir.
There's one final question. The chair recognizes Chairman Martin for a question.
Yes, sir.
Gentlemen,
Go Dogs.
thank you. Okay, so you got me thinking about Georgia now. I have to regather myself for the question. No, it's a serious question.
That's what we do with witnesses on the stand.
Yes, and well done, you did. To follow up on Chairman Hunt's first question relative to a felony case where, just statistically, it's easier to convince 6 people for unanimity than 12.
Yes.
I want to make sure the question came about when you said, well, take care of all those 6-person civil cases. If you want a 12-person, you have to wait. I want to be careful in striking this balance to get rid of the court backlog, that if we have a felony case where the defendant does not wish to have a 6-person case, perhaps can't bail out of jail, is not offered bail, that they don't forever go to the bottom of the list. So if you could just address that very quickly.
No, that
was my question.
That's a great, Mr. Chairman, that's a great point. Members in this body do know that are practicing lawyers that you can apply for what's called a speedy trial. Every criminal defendant is entitled to a speedy trial, may make a speedy trial demand. And so those that have made those speedy trial demands and do want a 12-person jury will proceed accordingly. And what this will do is help shift some of those civil cases out of the way. And really we're talking about space accommodation. It all comes down to exactly what we're doing in this room. We don't have enough, we can't get social distancing without spacing people in 341 and in the gallery. It's no different than a courthouse. So what you're experiencing here is the same problem that every judge is facing in their courthouse to deal with bringing in a jury, selecting a jury, and then having them sit in the courtroom at a safe distance from each other in order to hear a case and make a decision. Let me ask you this. But for the fact that you have a sworn constitutional duty to be here today, do you think that we're going to have a lot of volunteers to jury pools when they're called up during this COVID pandemic, if they know they're going to be quartered in a room and have to sit with others that may or may not be doing the things that are important to keep safe, and they have to sit and listen to a trial for 1, 2, 3, and 4, 5 or more days? I think the answer is, I think you know the answer. The answer is that people are not going to show up. And what does that do to our system of justice? It slows it down for each and every defendant who is deserving and wants a fair trial. And I would commend this bill to you, and I'll take one more question if there is one.
There are no more questions.
Thank you very much for listening to me go on for a while. I appreciate your time, and I appreciate your favorable consideration of Senate Bill 405.
The gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. And the clerk will unlock the machine and call the roll.
Alexander, Anulowicz, Barr, Barton, Barton, Belton, Bennett, Bentley, Benton, Beverly, Blackman, Bodie, Bruce, Burns, Carpenter, Carson, Chokus, Clark H., Collins, Cooper, Corbett, Dempsey, Dickey, Dollar, Drenner, Dubnik, Abstration, England, Irwin, Fleming, Fry, Gaines, Gardner, Glanton, Gravely, Harrell, Hatchett, Hawkins, Hitchens, Holcomb, Holmes, Houston, Hughley, Jackson M., Jaspers, Jones J., Kelly, Kendrick, Knight, LaHood, LaRicchia, Lumsden, Martin, Mathiak, McCall, Morris G., Newton, Nix, Oliver, Parrish, Parsons, Petrie, Perkel, Powell, Reeves, Rhodes, Rich, Ridley, Rutledge, Scoggins, Setzler, Silcox, Smith L., Smith R., Smith V., Smyrie, Stevens R., Tankersley, Tanner, Tarvin, Taylor, Thomas E., Trammell, Washburn, Watson, Welch, Werkheiser, Wiedauer, Williams A., Williamson, Yurda, Allen, Bazemore, Bernau, Cannon, Carter, Clark D., Clark J., Cook, Davis, Douglas, Dreyer, Donahue, Earhart, Evans, Frazier, Gilligan, Gertler, Henson, Hill, Hogan, Holland, Holly, Hobson, Howard, Hutchinson, Jackson D., Jones S., Jones T., Jones V., Couch, Kennard, Lopez Romero, Marin, McLean, McLaurin, McLeod, Meeks, Mitchell, Moore B., Moore C., Morris M., Nelson, Wen, Paris, Prince, Pullen, Robichaud, Saints, Schofield, Scott, Shannon, Sharper, Smith M., Stevens M., Stevenson, Thomas A.M., Turner, Walensky, Wilkerson, Williams M.F., Williams N., Wilson, Beasley Teague, Bonner, Buckner, Burchett, Caldwell, Campbell, Cantrell, Dickerson, Dukes, Gamble, Gilliard, Gordon, Green, Gullett, Jones, J.B., Kirby, Lott, Mathis, Metz, Momtahan, Park, Pruitt, Rogers, Singleton, Stovall, Williams R., Beasley Teague, Burchett, Burns, Burchett, Efstration, Gilliard, Jones J., Kennard, Meeks, Morris M., Nelson, Prince, Smyrie, Thomas E.
Have all members voted? And check the board. If so, the clerk will, wait. Have all members voted? And check the board. If so, the clerk will lock the machine. On the passage of the bill, the yeas were 109, the nays were 41. The bill, having received the requisite constitutional majority, is therefore passed. Chair recognizes Chairman Welch. For a motion.
Yes, I move that the rules of the House be suspended so that a bill may be read for the first time and assigned to committee.
Clerk will read the caption.
Unnumbered House Bill by Representative Welch, the 110th and others, to be entitled an act to authorize Henry County, Georgia to exercise all redevelopment and other powers under the Georgia Constitution.
On the gentleman's motion that the rules of the House be temporarily suspended so a bill can be read for the first time and assigned to committee, is there objection? The chair hears none. Intergovernmental coordination. Chair recognizes Representative Burchett for a motion.
Thank you, Madam Speaker. I'd like to make a motion to recommit Senate Bill 407 back to rules.
On the gentleman's motion that we recommit, Senate Bill 407 back to rules, is there objection after the clerk reads the caption?
Senate Bill 407 by Senator Harper the 7th, Heath the 31st, Burke the 11th, Harrell the 40th, and others, to be entitled an act to amend Chapter 6 and Title 12 of the official code of Georgia annotated relating to forest resources and other plant life.
Is there objection to recommit Senate Bill 407 back to rules? The chair hearing none, it is so ordered.
Okay, we're back on the rules calendar. Ready? Clerk will read the caption to Senate Bill 451.
Senate Bill 451 by Senator Kennedy, the 18th, Cowser, the 46th, Hufstetler, the 52nd, and others, to be entitled an act to amend Article 3 of Chapter 3 of Title 9 of the official code of Georgia annotated relating to limitations on recovery for deficiencies connected with improvements to realty and resulting injuries, so as to clarify actions that may be brought pursuant to Code Section 9.351. This bill having referred to Committee on Judiciary, that committee recommends that this bill do pass.
Chair recognizes Chairman F. Stration to present the bill.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I bring today to you Senate Bill 451. This legislation was requested by the Attorney General of Georgia, who has made very clear a priority of addressing Georgia's previous status as one of the worst states for human trafficking and the issues that we've seen around Medicaid fraud and other statewide responsibilities that we have, where the Attorney General is conducting investigations and working to facilitate the use of investigations to best serve Georgians throughout the state. Where's my friend, Representative Rhodes, when I need him? Mr. Speaker, I'd like to now tell the House about Senate Bill 451, just one of the many great bills that I have on the calendar today. The best part about being a chairman of a committee is you get to hear so many Senate bills, and when you ask who the House sponsor is, they say, well, I thought you, Mr. Chairman, you're willing to hear our bill. So I apologize. Let me start over. This bill is concerning this legislation was already passed by the House unanimously. So you're familiar with, I previously presented a bill to you where the Court of Appeals interpreted the statute of repose to prevent people seeking coverage for a warranty, such as a 20-year roof warranty for your home. And the Court of Appeals determined that Georgia law, an interpretation of Georgia law, prohibits that coverage. So Consumer Advocate Clark Howard said that the General Assembly needs to take action on this to address the statute of repose language as soon as the General Assembly gets back into session, and Senator Kennedy introduced a companion bill while my bill was pending in the state Senate. I'd ask for your favorable consideration and for the House to unanimously pass this same language just as you did earlier this year. I'll be happy to answer any questions.
I do not see any questions.
I'll yield the well. Thank you, Mr. Speaker.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of the passage of the bill will vote yes. Those opposed will vote no. And the clerk will unlock the machines and sound the roll.
Alexander, Anulowitz, Barr, Barton, Belton, Bennett, Bentley, Benton, Beverly, Blackman, Bodie, Bruce, Burns, Carpenter, Carson, Chokus, Clark H., Collins, Cooper, Corbett, Dempsey, Dickey, Dollar, Drenner, Dubnik, Evstration, England, Irwin, Fleming, Fry, Gaines, Gardner, Glanton, Gravely, Harrell, Hatchett, Hawkins, Hitchens, Holcomb, Holmes, Houston, Hughley, Jackson M., Jaspers, Jones, Kelly, Kendrick, Knight, LaHood, LaRicchia, Lumsden, Martin, Mathiak, McCall, Morris G., Newton, Nix, Oliver, Parrish, Parsons, Petrie, Perkel, Powell, Reeves, Rhodes, Rich, Ridley, Rutledge, Scoggins, Setzler, Silcox, Smith L., Smith R., Smith V., Smyrie, Stevens R., Tankersley, Tanner, Tarvin, Taylor, Thomas E., Trammell, Washburn, Watson, Welch, Werkheiser, Wiedauer, Williams A., Williamson, Yurda, Allen, Bazemore, Bernau, Cannon, Carter, Clark D., Clark J., Cook, Davis, Douglas, Dreyer, Donahue, Earhart, Evans, Frazier, Gilligan, Gertler, Henson, Hill, Hogan, Holland, Holly, Hobson, Howard, Hutchinson, Jackson D., Jones S., Jones T., Jones V., Couch, Kennard, Lopez Romero, Marin, McLean, McLaurin, McLeod, Meeks, Mitchell, Moore B., Moore C., Morris M., Nelson, Huen, Paris, Prince, Pullen, Robichaud, Saint, Schofield, Scott, Shannon, Sharper, Smith M., Stevens M., Stevenson, Thomas A.M., Turner, Walensky, Wilkerson, Williams M.F., Williams N., Wilson, Beasley Teague, Bonner, Buckner, Burchett, Caldwell, Campbell, Cantrell, Dickerson, Dukes, Gamble, Gilliard, Gordon, Green, Gullett, Jones, J.B., Kirby, Lott, Mathis, Metz, Momtahan, Park, Pruitt, Rogers, Singleton, Stovall, Williams R., Beasley Teague, Bonner, Campbell, Carson, Clark J., Cooper, Davis, Dickey, Gilliard, Gordon, Gravely, Hatchett, Jackson M., Nelson, Prince, Reeves, Scoggins, Scott, Williams R.
Okay, everybody look at the board and make sure that it is accurate. Everybody look at the board. Mr. Clerk, you may lock the machines. On the passage of Senate Bill 451, the ayes are 138, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. This House is going to stand in recess until 3:15.